Thank you for coming. Welcome. This is our 23rd annual Brennan Lecture in the State Courts and Social Justice. This is a program that is sponsored by the Institute of Judicial Administration, IJA, which I've been privileged to be a co-director of since 1991. And Troy McKenzie is here, another co-director of ours, and I don't know if Oscar is here tonight. IJA is sort of the principal arm to the judiciary, not the only arm, but the principal arm to the judiciary at the NYU School of Law. The organization's been around since 1947. It was a creation of Arthur Vanderbilt, who was the then legendary dean of NYU School of Law. And I have to say then legendary. The building is named after him. He had almost all of the justices of the state Supreme Court, chief justices of the state Supreme Courts here to celebrate the naming of the building during his lifetime. I mean, and that was his achievement. The reason I say then legendary dean, because we have legendary deans since then, and two of them are here in the audience, Ricky Revesz and my current boss, Trevor Morrison. So I need to be very careful that I spread the credit. I'm very proud of IJA because we have developed programs that attract state and federal judges from all over the country, and we are regarded by them as nonpartisan and non-ideological. So we have been able to attract people who are Democrats and Republicans, who are originalists and modern living constitutionalists, so we're just very proud of the fact that there's such a home here at NYU for that kind of activity. We have three principal activities. One is the Appellate Judges Program, which we conduct every summer. Neil Gorsuch, for example, had been in our program, as had Sonia Sotomayor. So this is an organization that unifies those two tendencies in American law. Now, we're regarded as the best program for new appellate judges in the country, which is a status that we're very proud of. It's due in part to the fact we're the only such program. Kidding aside, we also run an annual program on employment law for federal judges. We're now in our 20th year. We've completed our 20th year. We attract over 40 federal trial judges and some appellate judges to that program. And Judge Furman was on the faculty of the program. I'm sure there are other people here that have been involved. FJC, the Federal Judicial Center, has gone through the federal judiciary twice to give everyone an equal chance to be part of that program. A third centerpiece program is the Brennan Lecture, of which I'm very proud because we're honoring state judges, state courts. It's sort of a very funny thing. If a Martian were to come here and go to a major law school, they would get the impression that most of the law is made in federal courts. They would also get the impression that the primary guarantors of our liberties are federal courts. Now, they are important. They are primary guarantors. But we know that until the 1880s, there were not general federal courts. And so that the design was to rely on the state courts, and we still rely on the state courts for most of the important areas of private and public law in this country. So we are honoring not only Justice Liu, but we're also honoring the state judiciary through the Madison Lecture, through the Brennan Lecture. That was a faux pas on my part. Through the Brennan Lecture. Actually, I think Brennan was a more consistent advocate of the point of view that many in this building share than was Madison. But we're also, the Madison Lecture is a kind of forerunner of what we do. 23 years, and each year the speaker produces an article that's published by the NYU Law Review, and we're very pleased that the NYU Law Review editors are here. So that's all that I'm going to say. Now, just our now to-be legendary dean of the NYU School of Law, Trevor Morrison, who's a product of Columbia and the Canadian legal education system. The Canadian education.
Well, it's true Columbia's to the north of here. It's not quite in Canada, but it's true I was there before I knew anything about the law, too, which Sam and Troy and others will tell you continues to be true today. But I'm glad to welcome everybody here to the 23rd Brennan Lecture. I just want to say a word of thanks and ongoing thanks to Sam and to Troy and to Oscar Chase for their leadership of IJA, which is a tremendously important part of this law school. And for the reasons that Sam was just articulating, I think we can justly be proud of the fact that it's a very important part of American public life, of the law in this country, and of supporting the judiciary, both state and federal, though of course tonight we're focusing on the state courts. I suppose it might be true, Sam might be right, that if a Martian were to land and observe goings-on in this law school, that Martian would think that the most important things that happen in federal court. I tend to think it's more likely they would conclude that the most important things happen in law reviews. But either way, that would very arguably be an error. And in fact, the work of the state courts is, of course, indispensable to the administration of justice in this country. And of course, Justice Brennan, for as much as he was famous, and justly so, for his many years of dedicated service and vision on the US Supreme Court, is himself a fantastic exemplar, maybe the leading exemplar of excellence on the state court level as well. We're, of course, very, very proud of our own graduate, Judith Kaye, who was the first Brennan lecturer, and both Justice Brennan and Judge Kaye themselves talked at some length in writing and in their lectures about themes that I understand our guest today, our honor speaker today, will be addressing, namely the role of state high courts in elaborating constitutional norms through state constitutions and the extent to which that norm elaboration ought to track what the federal courts say about the US Constitution or ought to chart their own path. An important issue, an ongoing and enduring issue ever since it was explored by the likes of Brennan and Kaye, and today we get to add the insights of Justice Goodwin Liu to that tradition. We're really grateful that Justice Liu is here with us, among many friends and admirers, and it's my task then to introduce the person who will introduce him, and that's Meir Feder. Meir's a partner at Jones Day, where he heads their Issues and Appeals Office in New York. He's a renowned appellate advocate before the Supreme Court of the United States, the federal courts of appeals, and state high courts across the country. Earlier in his career, he served in the U.S. Attorney's Office in the Southern District of New York and was a clerk to Justice Souter. He is admired by many of us as a friend and active member of IJA, and we're very grateful that tonight he can introduce Justice Liu. Meir.
So, first of all, I apologize for the sort of long wind-up in getting to our featured speaker. I feel like maybe Dean Morrison should have passed me a baton that he got from Sam, and but without further ado, I'll say that it is a tremendous honor for me this evening to introduce Justice Goodwin Liu of the California Supreme Court to deliver the 23rd Annual Brennan Lecture. In welcoming Justice Liu, we have the benefit of hearing from someone who's not only a distinguished jurist, but also an unusually accomplished legal scholar. Justice Liu is, really no other way to put it, a classic American success story. He is a child of immigrants from Taiwan, a product of the public schools of Sacramento, California. He attended Stanford for college, where, unlike the typical pre-law liberal arts major, he got his degree in biology. He went from there to do a Rhodes Scholarship at Oxford, and at Oxford, he earned a degree in what I have to imagine is the unusual combination of philosophy and physiology. I don't think that's offered as a double major at most places. Following Oxford, Justice Liu helped to launch AmeriCorps, the National Service Program. He spent 2 years in DC and then moved on to law school at the Yale Law School. from which he graduated in 1998. After law school, Justice Liu clerked for Judge David Tatel on the D.C. Circuit and Justice Ruth Bader Ginsburg, and finding the time in between those clerkships to spend a year as a special assistant at the U.S. Department of Education. He also, following the clerkships, he practiced at O'Melveny & Myers as an appellate lawyer. Certainly a role close to my heart, and went quickly from there to join the faculty at the University of California, Berkeley Law School, which at the time I guess was probably Bolt Hall. It is now only informally Bolt Hall, but still Cal Berkeley. He quickly became a prominent legal scholar, particularly well known for his extensive writing on constitutional issues and education. And he has continued to be involved in education issues throughout his career. I will skip ahead to 2011, when he was appointed by Governor Brown to his current position as an Associate Justice of the California Supreme Court. I should mention that Justice Liu joined that court when he was at the ripe old age of 40. So he is still it's always daunting to come into contact with people who have accomplished so much so young, but we have that benefit tonight. And I should add that it is particularly fitting in more than one way for Justice Liu to be delivering tonight a lecture addressing the important role of state courts in interpreting state constitutional provisions that are similar to provisions of the federal Constitution. The more obvious way this is fitting is that this year marks the 40th anniversary of Justice Brennan's classic article on the subject, State Constitutions and the Protection of Individual Rights. And so there could be no better venue than the Brennan Lecture for Justice Liu to deliver this talk. The other way in which this is fitting is that Justice Liu himself, I think, represents a renewed focus not only in the legal academy but also in the real world on the important role that the state courts play in our system. What I mean by this is that when he was appointed, by appointing a nationally prominent cutting-edge legal scholar like Justice Liu, Governor Brown went in a new and what at the time was certainly an unusual direction for state Supreme Court appointments. And it worked so well that Governor Brown's next two appointments following Justice Liu were a Stanford law professor and a former acting principal deputy U.S. Solicitor General. The California Supreme Court itself has always been an extraordinarily respected court, but one can see that Justice Liu has set a path for what, even for that court, or really for any court, would have to be regarded as an extraordinary infusion of legal talent. And I think that that collection of talent both reflects and perhaps will drive a renewed recognition of the importance of state courts in our system. Perhaps even someday the NYU Law School may reflect some focus on what happens in state as well as federal courts. And aside from the Brennan Lecture, that is. And so I think that makes it fitting that we'll hear Justice Liu this evening address the important role of those courts in the 23rd Annual Brennan Lecture on the topic of state constitutions and the protection of individual rights, a reappraisal. Justice Liu.
Well, thank you, Meir, for that tremendous introduction. This is the first time that I've ever had an introduction that was preceded by an introduction that was preceded by an introduction. And all I can take away from that is either you all really like me or you don't want me to talk very long. I actually thought what you were going to say was that I'm an exemplar of federalism because some of you know that I was nominated for the federal bench before landing in this gig. And as I say, it made me a deep believer in federalism. It's a great honor to be here at NYU to give the Brennan Lecture, the 23rd Annual Brennan Lecture on State Courts and Social Justice. I want to thank the Institute of Judicial Administration, Sam and Troy and Oscar, for the tremendous work that you do for the judiciary. My friend Trevor Morrison, who I've known for quite some years. I'm grateful to all the judges who are in attendance, in particular the judges from the New York Court of Appeals and the appellate courts of New York, as well as the New Jersey Supreme Court and appellate judges there. My classmate, Jesse Furman, is here from the Southern District, doing a great job there. Several ALI colleagues, American Law Institute colleagues, Ray Loyer from the Second Circuit, Margie Marshall, Ricky, of course. I'm going to forget people, Carol and Evan and many others. It's such a wonderful organization. And in addition, I'm so happy to see colleagues from NYU, Columbia, and Yale. I have students here from different walks of life, including Yale, Bolt, former externs here. So who knew I had so many friends in New York? This is really tremendous. And I want to thank many other friends who have come, some from very long distances, to be with me today. I also want to acknowledge the presence today of Professor Bob Williams from Rutgers, who those of you who have even dabbled in this field must know of his immense contributions to the understanding of state courts and state constitutions. And so it's a great honor to have Bob here today. So yes, the inspiration for my lecture this evening is the 40th anniversary of Justice Brennan's 1977 article in the Harvard Law Review, State Constitutions and the Protection of Individual Rights. As of 5 years ago, this article ranked 9th among the most cited law review articles of all time. Among the top 10 most cited articles, Justice Brennan's is the winner for brevity at a slim 16 pages, beating out Oliver Wendell Holmes's The Path of the Law at 22 pages. Think about that for law reviews today. So in his article, Justice Brennan urged state courts to engage in independent interpretation of the individual rights guarantees in state constitutions, especially in areas where the U.S. Supreme Court had, in his view, unduly constricted the scope of analogous rights in the federal Constitution. In his words, quote, "State courts cannot rest when they have afforded their citizens the full protections of the federal constitutions. State constitutions, too, are a font of individual liberties, their protections often extending beyond those required by the Supreme Court's interpretation of federal law. The legal revolution which has brought federal law to the fore must not be allowed to inhibit the independent protective force of state law, for without it, the full realization of our liberties cannot be guaranteed." So the legal revolution of which Justice Brennan spoke consisted of Warren Court decisions giving life to the equal protection and due process clauses of the 14th Amendment, as well as decisions applying various provisions of the Bill of Rights to states. By 1977, however, President Nixon had appointed 4 new justices to the court, and Justice Brennan sensed that change was afoot. At the same time, he observed, state courts have, in his words, independently considered the merits of constitutional arguments and declined to follow opinions of the United States Supreme Court they find unconvincing, even where the state and federal constitutions are similarly or identically phrased. The essential point I am making, Justice Brennan said, is not that the U.S. Supreme Court is necessarily wrong in its interpretation of the federal Constitution, or that ultimate constitutional truths invariably come prepackaged in the dissents from decisions of the court. It is simply that the decisions of the court are not and should not be dispositive of questions regarding rights guaranteed by counterpart provisions of state law. Rather, state court judges and also practitioners do well to scrutinize constitutional decisions by federal courts and only follow them if they are logically persuasive and well-reasoned. Okay. So over the years, Justice Brennan's article has spawned an expansive literature on judicial federalism. New Jersey Supreme Court Justice Stuart Pollock called this article the Magna Carta of state constitutional law. The late Chief Judge Judith Kaye, delivering the first Brennan lecture right here at NYU in 1995, said, "I still remember the excitement those stirring words in his article generated. Many of us had grown so federalized, so accustomed to the Supreme Court of the United States as the fount of constitutional wisdom, that we barely remembered our state even had a constitution." But this newfound exuberance for judicial federalism also drew criticism. One commentator called Justice Brennan a false prophet of federalism, whose real objective was to encourage state court activism in favor of liberal causes. Others described state constitutionalism as a strategy for, quote, nose-thumbing at the US Supreme Court and as, quote, a kind of forum shopping for liberals. Harvard Law professor Paul Bator expressed misgivings about the extent to which Justice Brennan seems to assume that state constitutional law is simply available to be manipulated to negate Supreme Court decisions which are deemed unsatisfactory. So state constitutionalism, critics argued, boils down to a kind of tactic for evading federal precedents that state courts don't like. Well, as to Justice Brennan's belief in federalism, it's worth noting that in addition to serving 5 years on the New Jersey Supreme Court, Justice Brennan was intimately involved in the 1947 revision of the New Jersey Constitution, which came to be viewed as a model state constitution for the nation. But however devoted he was to federalism, it is fair to say that what his 1977 article lacked, and what judges and commentators then struggled to articulate, was a theory of interpretation to guide state courts in deciding when they should depart from federal constitutional decisions in construing analogous provisions of state constitutions. And the premise of this quandary is that state constitutional law must go its own way, not in order to achieve a particular result, but because it is jurisprudentially an independent body of law. State courts, accepting this premise, began to ask, what is the methodology of this jurisprudence? What is the proper way to interpret state constitutions? And how is such interpretation different from interpretation of the federal Constitution? And these have been the dominant questions of judges and scholars in theorizing the legitimacy of state constitutionalism. What I want to suggest this evening is that these questions, while interesting, are not the main fulcrum on which the legitimacy of state constitutionalism rests. The legitimacy of state constitutionalism does not primarily depend on the development of a distinctive state-centered jurisprudence. Many of our basic rights and liberties are protected by similar language in the federal and state constitutions. State courts and federal courts can and do have principled disagreements on the meaning of those rights and liberties. And when state courts depart from federal precedent, it may be because a state's constitutional text or history points to a different result, and state courts should, of course, look first to state-specific sources. But when there is no state-specific text or history to guide the analysis, it is no embarrassment for a state court to disagree with federal precedent on the basis of constitutional reasoning that transcends state boundaries. This redundancy in interpretive authority is one way that our system of government channels disagreement in our diverse democracy. And so my contention is that the legitimacy of state constitutionalism mainly turns on a proper understanding of the structure of our federal system, not on matters of interpretive methodology. So, to bring the problem of legitimacy into slightly greater focus, it's helpful to observe at the outset that the problem does not really arise in cases where state constitutional provisions materially differ from analogous federal provisions in their text, purpose, or history. For example, the religion clauses of many state constitutions differ from the federal free exercise and establishment clauses, and state courts have interpreted those provisions to be more protective of religious liberty or to erect a higher wall of church-state separation than their federal counterparts. Many state constitutions also have provisions that mandate government provision of social services, such as education. And state courts have held that these provisions confer positive rights that the Supreme Court has refused to recognize under the federal Constitution. In these areas, it is no surprise that state courts interpreting state constitutions may construe individual rights more expansively than federal courts interpreting the federal Constitution. But what about cases involving state constitutional provisions that do not meaningfully differ from their federal analogs? How should state courts interpret such provisions? Well, a number of state courts have set forth lists of criteria or factors to determine when divergence from federal precedent is warranted. As one example, the Washington State Supreme Court considers 6 non-exclusive factors. I'll quote from their precedent. Number 1, the textual language. Number 2, differences in the textual language. 3, constitutional history. 4, pre-existing state law. 5, structural differences. 6, matters of particular state or local concern. The Illinois Supreme Court has said it considers whether something is in, quote, the language of our Constitution or in the debates and the committee reports of the Constitutional Convention, whether those things justify a departure from federal precedent. And the high courts of California, Connecticut, New Jersey, Pennsylvania, among many others, have stated similar criteria. The problems with this approach have been elucidated by Professor Williams, among others. Most significantly, it treats federal precedent with a presumption of correctness that has no sound basis in our federal system. Just as the Supreme Court, when interpreting a provision of the federal Constitution, does not accord a presumption of correctness to any state's interpretation of an analogous state constitutional provision, or even to an interpretation adopted by a majority of states, there is no reason why a state court, when interpreting a provision of its state constitution, should accord a presumption of correctness to the Supreme Court's interpretation of an analogous provision. A state court should, of course, give respectful consideration to relevant Supreme Court decisions, just as it should give respectful consideration to relevant decisions of sister states. And a state court may often be persuaded that the Supreme Court's approach is correct and worthy of adoption. But the point is that state courts have the prerogative and duty to interpret their state constitutions independently. A state court may consult precedent as part of, but not in lieu of, its own independent analysis of a state constitutional issue. When a state court does this and concludes that federal precedent is unpersuasive, is it evasive or results-oriented for the state court to adopt essentially the dissenting view in a federal decision as a matter of state law? I think this kind of criticism misses the mark. Suppose a state court interpreting its state constitution declines to follow the Supreme Court's decision in United States versus Leon, adopting the good faith exception to the exclusionary rule under the Fourth Amendment. Suppose the state court reaches this result by analyzing the same textual, historical, and practical considerations that the Supreme Court analyzed in Leon. I do not think the state court can be said to have been any more results-oriented than the justices who dissented in Leon. Many constitutional issues are just difficult, and there are principled disagreements. Similarly, there is nothing evasive about such departures unless one assumes wrongly that federal precedent somehow binds state courts in their interpretations of state law. The problem is not that such departures are evasive or results-oriented. The problem, instead, is that the reasons for departing are said to be illegitimate when they include no state-specific grounds and consist of analysis no different than what a federal court would undertake in addressing the same issue under the federal Constitution. if state courts should not accord a presumption of correctness to federal decisions, if they should instead develop an independent constitutional jurisprudence, then shouldn't that jurisprudence rest on state-specific considerations that distinguish the meaning of state constitutional provisions from their federal analogs? Or does judicial federalism essentially give litigants 2 bites at the same constitutional apple? Consider as another example the Supreme Court's 1988 decision in California versus Greenwood, which held that police can search your trash left at the curbside of your home without a warrant. Although many courts have adopted this rule as a matter of state constitutional law, several have not. The New Hampshire Supreme Court found Justice Brennan's dissent in Greenwood more persuasive and concluded that society is prepared to recognize the expectation of privacy in one's trash as reasonable. The Washington State Supreme Court opined that a person might reasonably expect a licensed trash collector to collect your trash, but this expectation does not extend to the police. And the New Jersey Supreme Court found Greenwood, I quote, flatly and simply wrong as to the way people think about garbage. The court did not rely on state-specific grounds, instead making clear that, and I quote, there is no unique New Jersey state attitude about garbage. I am not going to make any more jokes about this point. A similar story can be told about same-sex marriage. In 2003, the Massachusetts Supreme Judicial Court, thanks to Margie Marshall, became the first state high court to hold that same-sex couples had a constitutional right to marry. At the time, the only federal authority on point was Baker versus Nelson, an appeal from a Minnesota Supreme Court ruling against same-sex marriage that the US Supreme Court had dismissed for want of a substantial federal question. 5 years later, the California Supreme Court held unconstitutional the state's laws restricting marriage to opposite-sex couples, broadly ruling that discrimination on the basis of sexual orientation is subject to strict scrutiny under California's Equal Protection Clause. 5 months after our decision, the Connecticut Supreme Court reached the same conclusion on largely the same analysis. At the time, the US Supreme Court had not suggested that sexual orientation discrimination warranted any greater scrutiny than rational basis review. These state courts did not employ any state-specific reasoning. They simply disagreed with federal precedent, employing similar analytical approaches but reaching different doctrinal conclusions. There are many other examples like this, and not all of them are liberal in their results. After the Supreme Court's decision in Kelo versus New London, some state high courts read their state constitutions to confer greater property rights, protection of property rights against eminent domain. The Ohio Supreme Court agreed with the dissenters in Kelo, concluding that Kelo had construed the concept of public use too expansively. The Supreme Court of South Dakota disagreed with Kelo's public benefit rationale and construed public use to mean use by the public. These courts, too, did not point to any meaningful textual differences between the state and federal takings clauses or to any other state-specific factors. They just reasoned from general principle. So as Emory Law Dean Robert Shapiro has observed, the discomfort with these decisions may be traced to the conventional understanding of a constitution as an expression of a sovereign people's fundamental values. One answer to the countermajoritarian difficulty is that judges, when interpreting a constitution, do not act in the mode of Ronald Dworkin's Hercules, overriding the democratic choices of the people. Rather, constitutional interpretation requires judges to vindicate core principles that reflect a permanent consensus of the people over the transient policy preferences of a shifting majority. This understanding, as applied to the federal Constitution, is premised on the coherent identity of the American people as an enduring entity with shared values. The applicability of this understanding to state constitutions is less clear. Of course, each state's constitution is, as a formal and historical matter, the enactment of the people of each state, but many provisions of state constitutions do not lend themselves to state-specific understandings, and in those areas it is not obvious that states define meaningful communities of value. Just as there is no unique New Jersey attitude about reasonable expectations of privacy in garbage, there is no California concept of equal protection that is distinct from the analogous concept in the federal Constitution. In these cases, the state courts and the Supreme Court are not interpreting different concepts of equal protection or unreasonable searches and seizures. They are offering different interpretations of the same concept. And as Yale law professor Paul Kahn has said, the common object of that interpretation is American constitutionalism. For several reasons, it should not be surprising that state courts often interpret state constitutional provisions without relying on state-specific sources. As an historical matter, state courts do not inherit a comprehensive tradition of elaborating basic rights by reference to state-specific sources. During the founding era and throughout the 19th century, the Bill of Rights was understood to apply only to the federal government. Before the process of selective incorporation, the protection of basic liberties was primarily the concern of state courts interpreting state law. This historical role of state courts should not be exaggerated in terms of its actual results, which were uneven at best. But what is notable is that state constitutional decisions from this era often employed concepts of natural law and common law reasoning that transcended state-specific texts or understandings. For example, the Tennessee Supreme Court in 1831 declared the principle of non-retroactivity of state laws impairing vested rights on the basis of, quote, eternal principles of justice, which no government has a right to disregard. The Connecticut Supreme Court recognized a criminal defendant's right against double jeopardy and right to counsel as a matter of custom or common law. And the Arkansas High Court in 1853, noting that the state constitution contains no takings clause, nonetheless enforced that principle, quote, as a law of natural justice. Massachusetts Chief Justice Lemuel Shaw described this constitutional universalism when he wrote in 1857, I quote, "In considering constitutional provisions, especially those embraced in the Massachusetts Declaration of Rights and the amendments of the Constitution of the United States, in the nature of a Bill of Rights, we are rather to regard them as the enunciation of great and fundamental principles than as precise and positive directions and rules of action. Many of them are so obviously dictated by natural justice and common sense and would so plainly be obligatory upon the consciences of legislators and judges without any express declaration that some of the framers of state constitutions and even the convention which formed the Constitution of the United States did not originally prefix a Declaration of Rights." With the rise of legal positivism, appeals to natural justice have given way to modes of constitutional reasoning such as originalism that emphasize communal rather than universal understandings. But the notion of states as sites of communal identity with respect to basic liberties has also given way to new understandings in light of our nation's second founding and reckoning with slavery. The first sentence of the 14th Amendment says, I quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." In addition to overruling Dred Scott and securing the citizenship of Black Americans, this sentence makes clear that national citizenship is the primary political identity of the American people, and that state citizenship is secondary and derivative, a function of where a citizen of the United States chooses to reside. As case law makes clear, states lack an essential attribute of sovereignty with respect to American nationals. They have no authority to control their borders or to restrict state citizenship apart from adopting reasonable requirements for bona fide state residence. Our citizens thus have, as Justice Kennedy has said, two political capacities, one state and one federal, and these capacities are not vestments that we can only wear one at a time. Under the Citizenship Clause, one cannot be a citizen of a state without also being a citizen of the United States. The primacy of national citizenship and derivative nature of state citizenship are today reflected in the porousness of state boundaries and their limited relevance in the formation of political and cultural identity. consider in this regard the ease and extent of mobility of people between states, the national and global integration of the economy, the nationalization of consumer culture, think Amazon, Walmart, and the concentration of mass media, the expansion of the federal government, the rise of national political parties, the strength of powerful national lobbies have also exerted a homogenizing influence. Although geography can demarcate subnational communities, the ones that most readily come to mind, for example, urban versus rural residents, those do not track state lines. As a matter of constitutional design and contemporary reality, then, the members of a state polity are part of the national polity. The institutions of state government they create exist not only to satisfy their own desires concerning the character and content of political life within the state, but also to satisfy the wishes of the national polity, of which they are members, concerning the character and content of political life throughout the nation. It is thus no accident that state constitutionalism in many areas has not invoked the distinctiveness of a state's history, values, or character, what SUNY Buffalo law professor James Gardner has called a romantic sub-nationalism. This is not to say that there is no such thing as state identity, or that states cannot be meaningful political subcommunities of an internal integrity and cohesiveness, but it is to say that many fundamental principles, whatever their origins, in states' constitutions are today properly and actually understood as transcendent American principles. The legitimacy of state constitutionalism must therefore rest on a justification for redundancy between state and federal courts in interpreting shared constitutional principles, and here is where many state judges feel a certain anxiety. If we accept that federal courts and state courts are often interpreting a common object, and if that object is national in character, then why shouldn't the interpretations of the US Supreme Court be controlling? Of course, they are not controlling in the formal sense that the Supreme Court does not control state court interpretation of state law. But if a state court and the Supreme Court are deciding the same substantive issue, does a state court's departure from federal authority rest on a bona fide, independent and adequate state ground, simply by virtue of labeling it state constitutional law? The problem here, to be clear, is not that state courts lack competence to declare rights held in common by our nation's people. Although state constitutions define the existence and powers of state courts, the Supremacy Clause of the federal Constitution makes clear that, I quote, "the judges in every state shall be bound by federal law, including the federal Constitution." So, state courts are thus obligated and entrusted to interpret constitutional principles whose reach extends beyond state borders. But when state courts interpret the federal Constitution, they are acting as instrumentalities of federal authority subordinate to the Supreme Court. Why do state courts have independent authority to speak on matters of American constitutional law outside the chain of federal judicial command? This question goes to the heart of the rationale for judicial federalism. One kind of answer to why our system allows 2 bites at the same apple is that state courts and federal courts are differently situated when it comes to interpreting constitutional rights. NYU law professor Burt Newborn famously argued that state courts are less favorable forums than federal courts for litigants seeking enforcement of constitutional rights, but there are considerations that cut the other way. First, federal courts may under-enforce certain constitutional norms because of institutional rather than analytical concerns, and one of those institutional concerns is federalism. The Supreme Court may decline to enforce a constitutional right to its full conceptual boundaries because of concern that any interpretation it renders would not only bind the federal government, but also impose uniformity on the states. This concern obviously has no applicability to state courts. They need not worry that their constitutional rulings will constrain the prerogatives of other jurisdictions. Second, most state judges face electoral accountability in contrast to the life tenure enjoyed by federal judges. Although majoritarian pressures are thought to make state courts less responsive than federal courts to individual rights claims, the evidence is mixed. Some studies have found that state appellate courts fare no worse, and in some areas fare better, than federal courts in enforcing individual rights. And despite Hamilton's claim that insulating federal courts from political control would make them, quote, an excellent barrier to the encroachments and oppressions of the representative body, the modern Supreme Court has not generally strayed far from public opinion. Hamilton may have been a constitutional rock star, but he was no political scientist. Moreover, virtually all state constitutions are easier to amend than the federal constitution. Unlike a federal constitutional decision, a state constitutional ruling can be undone by popular initiative in 18 states, including California. Political accountability can induce judicial restraint, but political accountability can also lessen the counter-majoritarian difficulty, and perhaps counterintuitively may aid the legitimacy of counter-majoritarian decision-making by state courts. State courts may diverge from federal authority because of these institutional differences, or they may diverge because of sheer disagreement on the substantive meaning of a constitutional right. Either way, judicial federalism serves important purposes. Most directly, a state court can provide protection for basic liberties that would otherwise go unprotected in that state, but the impact of state rulings can be even more far-reaching. An accumulation of state decisions that depart from the federal precedent may induce the U.S. Supreme Court to reconsider the issue. In Mapp versus Ohio, the Supreme Court abandoned its earlier refusal to apply the exclusionary rule to the states, noting that more than half the states had adopted that rule by legislative or judicial decision, and emphasizing in particular the California Supreme Court's decision in People versus Kahan. In Batson versus Kentucky, the leading case on racial discrimination in jury selection, the court overruled Swain versus Alabama, noting that 5 state courts had departed from Swain in interpreting their state constitutions. And in Lawrence versus Texas, the court explained that, quote, criticism of Bowers versus Hardwick has been substantial and continuing, and it observed that, quote, the courts of 5 different states have declined to follow it in interpreting provisions in their own state constitutions parallel to the Due Process Clause of the 14th Amendment. State constitutional decisions can also shape the development of federal constitutional law when the Supreme Court confronts an issue for the first time. In New York Times versus Sullivan, the court observed that the actual malice requirement for proving defamation of a public official or political candidate had been adopted by 10 state courts. This citation was perhaps no accident because the author of New York Times versus Sullivan was none other than Justice Brennan. And the court has looked to state practice, including state constitutional law, to determine what constitutes a fundamental liberty interest protected by the 14th Amendment doctrine of substantive due process. Although federal courts have not borrowed from state constitutional doctrine to the same degree as state courts have used federal doctrine, these examples confirm that state courts and federal courts are engaged in a common dialogue when it comes to interpreting rights secured by both the federal and state constitutions. As Duke Law professor Joseph Blocker has said, the structure of American federalism need not be one that simply divides and separates judicial power. It can instead be one in which various interpretive bodies, both state and federal, are engaged in a shared enterprise of articulating constitutional values. State courts need not be independent laboratories. They can be part of the same general research institution as the United States Supreme Court. Against these considerations, it is said that state courts should proceed cautiously because of the general advisability in a federal system of uniform interpretation of identical constitutional provisions. Vertical uniformity has been a particular concern in the area of criminal procedure, where courts appear particularly worried that having 2 sets of rules sows confusion among the bench and bar and law enforcement over which rules to follow, and also leads to inconsistent results, whereby evidence from the same arrest or crime could be admissible in federal court but not state court. As a practical matter, it is questionable how significant this concern is in light of the already substantial vertical disuniformity in the criminal justice system. It is already the case that law enforcement officers must often navigate differing federal and state criminal procedure, evidentiary rules, and substantive criminal law. Moreover, when federal officers are especially concerned about admissibility of evidence or unsure which forum a prosecution will take place, they can always conform their conduct to the more protective state standard. Of course, simplicity and predictability are important virtues, but as the New York Court of Appeals has observed, the interest of state-federal uniformity is simply one consideration to be balanced against other considerations that may argue for a different state rule. Apart from its practical import, the allure of uniformity perhaps lies in a more expressive dimension. Vertical uniformity is considered a jurisprudential virtue, in part because it inhibits forum shopping and confers the appearance of neutrality. Some judges worry that giving different meanings to identical textual provisions may seem illogical or manipulative, or may breed distrust in the legal system. Others warn that independent state constitutionalism may diminish the moral authority of the U.S. Supreme Court. And as former Wisconsin Chief Justice Shirley Abramson has observed, some judges, I quote her, regard the state constitutional law movement as threatening the vision of one nation under law. But the American vision of one nation under law has always been complex, requiring an account of not only what various constitutional provisions mean, but also who gets to decide. It is no accident that the framers focused their efforts on crafting an intricate and durable structure of government, only later adopting, as amendments to the main document, a Bill of Rights, stated in general terms. In the compound Republic of America, Madison explained, the power surrendered by the people is first divided between two distinct governments, and then the portion allotted to each subdivided among distinct and separate departments. Hence, a double security arises to the rights of the people. The different governments will control each other at the same time that each will be controlled by itself. Federalist 51. The framers knew that a large and diverse nation committed to liberty will not often agree on one right answer to questions of intense public controversy. The redundancies built into our structure of government largely serve to channel and manage conflict, not necessarily to facilitate permanent resolution. The meaning and application of constitutional principles are thus the subject of ongoing interpretive conflict. Courts occasionally resolve such conflict through proper exercise of their delegated authority, but the fact that courts have authority to decide constitutional controversies does not mean that courts are oracles of constitutional truth with a capital T. As Justice Jackson said, I quote him, "Whenever decisions of one court are reviewed by another, a percentage of them are reversed. That reflects a difference in outlook normally found between personnel comprising different courts. However, reversal by a higher court is not proof that justice is thereby better done. There is no doubt that if there were a super Supreme Court, a substantial portion of our reversals of state courts would also be reversed. We are not final because we are infallible, but we are infallible only because we are final." Constitutional law is contested terrain, and we cannot expect our governmental institutions, including the courts, to resolve very deep and fundamental debates to everyone's satisfaction. In the long run, the legitimacy of American constitutionalism rests not only on the substantive merits of particular decisions, but also on the capacity of our governmental structure to give full expression to the debates themselves. Many of our most cherished constitutional principles are stated in general terms open to various meanings and application. The unique role of courts is that they frame a mode of contestation whereby each side lays claim to the same legal heritage, the same legal text, the same historical tradition. And it is that mode of contestation, as much as its substantive results, that binds us together as a nation. State constitutionalism is properly understood as a mechanism by which ongoing disagreement over fundamental principles is acknowledged and channeled in our democracy. Far from endangering the legitimacy of constitutional law. Interpretive pluralism is a source of its resilience and deep resonance with our diverse citizenry. When a state court departs from Supreme Court precedent to secure greater protection for individual rights, the state court registers a very forceful and public dissent. Whether or not it influences other states or eventually induces the Supreme Court to reconsider its precedent, the state decision carries forward a dialogue over the meaning of our basic liberties. In short, state constitutionalism is one way in which our structure of government provides an outlet for constitutional conflict. It is true that state constitutionalism cannot serve this function by authorizing downward departures from the floor of federal constitutional protections established by the Supreme Court. But this fact only serves to underscore the delicacy involved in adjudicating individual rights claims. On the most hotly debated issues, it is questionable to what extent the court can, in the words of Casey, call the contending sides of a national controversy to end their national division by accepting a common mandate rooted in the Constitution. The achievement of broad societal consensus on what the Constitution mandates is rarely, if ever, the direct byproduct of judicial decisions alone. Even Brown, let us not forget, went largely unenforced for over a decade until Congress and the president stepped in. The dangers involved in closing off debate in one direction should make us wary of closing off debate in the other as well. So, in closing, let me again thank NYU and IJA for continuing this annual tradition of the Brennan Lecture on State Courts and Social Justice. The composite work of the courts of the 50 states, Justice Brennan once wrote, probably has greater significance in measuring how well America attains the ideal of equal justice for all. The state courts of all levels must annually hand down literally millions of decisions which determine vital issues of life, liberty, and property of human beings of this nation. We should remind ourselves that it is those state court decisions which finally determine the overwhelming aggregate of all legal controversies in this nation. Justice Brennan believed, as I think you believe, that state courts matter, state law matters, and state constitutional law matters. My point this evening has not been that state courts interpreting state constitutions should depart from federal precedent more than they do, or that they should do so in particular areas. State courts should always give respectful consideration to federal precedent, and it may often be the case that the Supreme Court's holdings or analytical frameworks are well-reasoned and worthy of emulation. A state court may so conclude, but it should do so by applying its own judgment, not by applying a presumption of correctness to federal authority. A state court may recognize individual rights that go unrecognized by the Supreme Court because of textual or historical considerations unique to that state or its constitution. When state-specific sources bear on the constitutional issue, they should be consulted first. But there is nothing illegitimate about a state court rejecting the Supreme Court's interpretation of a parallel constitutional provision on grounds that are not state-specific. Our nation's framers understood that although a written constitution can and should declare our basic liberties, their precise contours are open to vigorous debate, often with no easy answers. Our structure of government disperses power in order to channel conflict, thereby minimizing the risk that any single branch of any single level of government will have unchecked authority to impose its version of constitutional truth. Justice Kennedy famously said that the genius of the framers was that they split the atom of sovereignty. The path to nationhood that began in Philadelphia would eventually travel through Appomattox and places like Selma and Little Rock and beyond. But the framers' act of fission bequeathed to us, somewhat paradoxically, a durable structure for fusing one nation out of a diverse democracy. Judicial federalism is part of this structure, and state constitutionalism is part of the conversation that sustains us as one people, we the people of the United States. So, if Justice Brennan's 1977 article was an invitation to begin that conversation in state courts, then I hope you will join me today in saying, let the conversation continue. Thank you all very much.